Welcome to our deep dive into Chapter XI of Offences Against Public Tranquility, covering sections 189 to 197. These laws are designed to safeguard society from disturbances caused by groups or individuals acting unlawfully. We'll explore the meaning of unlawful assemblies, riots, affray, and the legal consequences of promoting enmity between groups. Understanding these sections is crucial for anyone interested in law, public order, or social harmony. Let's begin by examining the core concepts and the purpose behind these legal provisions, setting the stage for a comprehensive journey through the intricacies of public tranquility laws. Section 189 focuses on preventing criminal force by groups of 5 or more people. The essence of this offence lies in the unity of purpose among the members. If 5 or more persons gather with a common object to commit acts like overthrowing government, resisting law, committing mischief, or using criminal force to obtain property or enforce rights, they form an unlawful assembly. The law distinguishes the consensus of purpose as an offence, separate from the actual crime intended. This section is foundational in understanding how group actions can threaten public order. Qualify as an unlawful assembly under Section 189. 1. The group must have a common object, such as overawing authorities, resisting legal processes, committing mischief, or using criminal force for possession or enforcement of rights. The object must be shared by all members, and mere presence does not make someone a member unless they intentionally join or continue as a member, knowing the assembly is unlawful. This ensures that only those actively participating or aware of the unlawful nature are held accountable. Section 189, 2, clarifies that anyone who remains in an unlawful assembly after realizing its unlawful nature is deemed a member and faces punishment. The penalty can include imprisonment up to 6 months, a fine, or both. This provision ensures that individuals cannot escape liability simply by claiming ignorance once they become aware of the assembly's unlawful status. It emphasizes personal responsibility and the importance of distancing oneself from illegal gatherings. Section 189, 3, addresses those who join an unlawful assembly knowing it has been commanded to disperse. This section targets individuals who defy official orders to break up, reinforcing the authority of law enforcement and the seriousness of such defiance. The law aims to deter people from joining or remaining in assemblies that have been officially deemed unlawful and ordered to disperse, strengthening public order. Section 189, 4, increases the severity of punishment for those who join an unlawful assembly armed with deadly weapons. The penalty can extend to 2 years imprisonment, a fine, or both. This reflects the heightened risk and potential for violence when weapons are involved, making it a more serious offence. The law recognizes the threat posed by armed groups and seeks to discourage such dangerous behavior. Section 190 introduces the concept of joint or vicarious liability. Every member of an unlawful assembly is held responsible for offences committed in pursuit of the assembly's common object. This means that even if only one member commits a crime, all members who share the common object are liable. The law ensures collective accountability, preventing individuals from escaping responsibility by claiming they did not personally commit the act. Section 190 to apply, there must be an unlawful assembly as defined in Section 189. 1. An offence committed by any member, and the offence must be in pursuit of the common object. Members must have voluntarily joined and known the common object. This ensures that liability is only imposed on those who are genuinely part of the unlawful purpose, reinforcing the importance of intent and awareness in criminal law. Musa Khan v. State of Maharashtra, the Supreme Court clarified that mere innocent presence in an assembly does not make someone a member of an unlawful assembly. Only those who share the common object, proven by direct or circumstantial evidence, are liable. This distinction protects bystanders and ensures that only active participants are prosecuted, upholding fairness in the application of the law. Consider the example where A, B, C, D, and E enter Z's house at night to beat him. A strikes Z's servant, B steals a chain, and C hits Z. All are guilty under Section 149 for causing injuries, but only B is liable for theft, as it was not part of the common object. This illustration demonstrates how liability is determined based on the shared purpose and individual actions within the group. Section 190 requires at least 5 persons sharing the common object for conviction. However, it is not necessary for all 5 to be convicted if the court is satisfied that 5 were present and shared the purpose, even if some identities are unknown. This ensures that the law is applied effectively, even when not all participants can be identified, maintaining the integrity of public order enforcement. Section 191 defines rioting as the use of force or violence by an unlawful assembly or any member in pursuit of the common object. A riot is essentially an unlawful assembly in action, distinguished by the use of force. The law targets not just the assembly, but the active disturbance caused, ensuring that those who escalate situations to violence are held accountable. To constitute rioting, the accused must be 5 or more, form an unlawful assembly, share a common object, and use force or violence in pursuit of that object. The use of force is central to distinguishing rioting from mere unlawful assembly. If the common object is not illegal, even the use of force does not amount to rioting, highlighting the importance of intent and purpose in criminal law. Force, as defined under Section 128 of BNS, is the essence of rioting. The offence lies in using force to achieve a common purpose. If the assembly's object is legal, force used does not constitute rioting. This distinction ensures that only unlawful actions are penalized, maintaining a balance between public order and lawful assembly. Spectators or bystanders attracted to riots by curiosity are not considered members of unlawful assemblies or rioters. The law protects innocent onlookers from prosecution, focusing only on those actively participating or sharing the unlawful object. This ensures fairness and prevents misuse of legal provisions against uninvolved individuals. Section 191(2) prescribes punishment for rioting, which may extend to 2 years imprisonment, a fine, or both. The law aims to deter violent group actions and maintain public peace by imposing strict penalties on those who participate in riots. Section 191(3) increases the punishment for rioting when armed with deadly weapons. The penalty can extend to 5 years imprisonment, a fine, or both. This reflects the greater threat posed by armed rioters and underscores the seriousness of such offences. Section 193(1) extends liability to owners or occupiers of land where unlawful assemblies or riots occur. The law holds masters criminally responsible for acts or omissions of their servants, regardless of their knowledge. Owners, occupiers, or those with an interest in the land must fulfill certain duties akin to police responsibilities, ensuring public order on their property. Section 193(2) addresses liability for those who benefit from riots committed on their land. If a riot occurs in the interest of the owner or anyone claiming interest, they are held responsible. This provision ensures that those who indirectly benefit from unlawful acts cannot escape accountability. Section 194 defines affray as fighting between 2 or more persons in a public place, disturbing public peace. The term originates from the French word affrayer, meaning to terrify. The offence lies in the terror caused to the public, making affray a public offence rather than a private dispute. The law emphasizes the impact on society, not just the individuals involved. To constitute affray, 2 or more persons must fight in a public place, disturbing public peace. The location must be accessible to the public, such as railway platforms, theatres, markets, or places of worship during open hours. The law distinguishes between mere verbal exchanges and actual fighting, requiring some use of force for the offence to occur. Affray must occur in a public place, defined as any location where the public habitually goes, regardless of legal right. Examples include railway stations, markets, and places of worship during open hours. The nature of a place can change from private to public depending on accessibility, highlighting the dynamic aspect of public spaces in law. For affray, actual fighting with some force is necessary. Mere exchange of abusive words, no matter how violent, does not amount to affray. The law requires a quarrel accompanied by force, and if one side is passive, it does not constitute a fight. This ensures that only genuine disturbances are penalized, not mere verbal altercations. Jagannath Sar 1937, 2 brothers quarreled and abused each other on a public road, attracting a crowd and causing a traffic jam. However, since no actual fight took place, the court held that no affray was committed. This case illustrates the importance of physical altercation in defining affray under the law. Affray and riot differ in key aspects. Affray cannot be committed in a private place, while riot can occur anywhere. Affray involves 2 or more persons, riot requires at least 5. Rioters first form an unlawful assembly, whereas affrayers need not. These distinctions help clarify the scope and application of each offence. Affray must be committed in a public place and is an offence against public peace, while assault can occur anywhere and is an offence against an individual. Affray involves actual fighting, whereas assault may involve gestures or preparations causing apprehension of force. The law distinguishes these offences to ensure appropriate penalties and protection. Section 194(2) prescribes punishment for causing affray, which may extend to 1 month imprisonment, a fine up to 1,000 rupees, or both. The law aims to deter public disturbances and maintain peace by imposing penalties on those who engage in fights in public places. Section 196 targets acts that promote enmity between different groups based on religion, race, place of birth, residence, or language. The law aims to prevent conflicts arising from mutual abuse and recrimination, punishing those who attempt to incite class hatred or enmity. Both successful and unsuccessful attempts are covered, emphasizing the importance of intent and effect in maintaining harmony. Intention to promote enmity must be inferred from the words used, their effect on the targeted class, and the state of feelings between communities. The law covers both successful and unsuccessful attempts, ensuring that even efforts to incite hatred are penalized. This approach helps maintain social harmony and prevent divisive actions. Section 196(1) prescribes punishment for promoting enmity, which may extend to 3 years imprisonment, a fine, or both. If the offence occurs in a public place of worship, the punishment increases to 5 years imprisonment and a fine. This reflects the heightened sensitivity and potential for conflict in places of worship. Gopal 1969, the court held that it is not necessary to prove actual enmity or hatred was caused between classes for conviction under Section 196. The law focuses on the nature of the act and its potential to incite division, ensuring proactive measures against divisive actions. Section 153AA of the Indian Penal Code has been repealed in the Bharatiya, Nyaya Sanhita, BNS. This change reflects ongoing legal reforms aimed at updating and streamlining criminal law provisions for better clarity and effectiveness. We've covered the definitions and punishments for unlawful assemblies, riots, affray, and promoting enmity. The law distinguishes between mere presence and active participation, emphasizes the importance of common object, and imposes joint liability for group actions. Understanding these concepts is vital for maintaining public order and ensuring justice. Public tranquility laws play a crucial role in preventing disturbances, protecting individuals, and maintaining social harmony. By addressing group actions, violence, and divisive behavior, these laws ensure that society remains peaceful and orderly. Their enforcement is essential for the well-being of communities and the protection of rights. Law enforcement agencies are tasked with upholding public tranquility laws, dispersing unlawful assemblies, preventing riots, and prosecuting offenders. Their role is vital in ensuring that these legal provisions are effectively implemented, safeguarding society from threats to peace and order. Awareness of public tranquility laws is important for all citizens. Understanding what constitutes unlawful assembly, riot, or affray helps individuals avoid unintentional involvement and encourages responsible behavior. Community education can reduce incidents and promote harmony. Legal reforms, such as the repeal of Section 153 AAIPC, demonstrate the evolving nature of criminal law. Updates ensure that laws remain relevant, effective, and aligned with societal needs. Continuous review and improvement are essential for maintaining justice and public order. Enforcing public tranquility laws can be challenging, especially in identifying active participants and distinguishing between innocent bystanders and offenders. Courts rely on evidence, intent, and participation to ensure fair prosecution. These challenges highlight the need for clear legal definitions and effective law enforcement. Public tranquility laws have a significant impact on society, deterring group violence, protecting property, and promoting harmony. Their enforcement helps prevent escalation of conflicts and ensures that individuals and communities feel safe and secure. Preventive measures, such as dispersal commands and monitoring assemblies, are crucial in maintaining public order. Authorities must act swiftly to prevent unlawful gatherings and potential riots, ensuring that disturbances are addressed before they escalate. The judiciary plays a key role in interpreting public tranquility laws, ensuring fair trials and delivering justice. Courts assess evidence, intent, and participation to determine liability, protecting rights and maintaining order. Their decisions shape the application and evolution of these laws. Public participation in maintaining tranquility is vital. Citizens must avoid unlawful assemblies, report disturbances, and cooperate with authorities. Responsible behavior and community support are essential for effective enforcement and social harmony. Education and outreach programs can help spread awareness about public tranquility laws, their importance, and consequences. Schools, community groups, and media play a role in informing citizens, reducing incidents, and fostering a culture of peace. In conclusion, Chapter XI of Offences Against Public Tranquility provides a comprehensive framework for addressing group violence, disturbances, and divisive acts. By understanding and respecting these laws, individuals and communities contribute to a peaceful and harmonious society. The ongoing evolution of legal provisions ensures that justice and order are maintained in a changing world. Thank you for joining us in this exploration of public tranquility laws. Stay informed, act responsibly, and support efforts to maintain peace and order. Understanding these legal provisions empowers you to contribute positively to society and uphold the values of justice and harmony.